So when someone gets wind of the fact that they may be under investigation, or sometimes a family member or friend involved in some type of conflict will threaten that someone is going to be arrested, that they're going to take charges out on them, which in Maryland it's perfectly legal and oftentimes happens, is that an individual goes to the commissioner themselves, not goes through the police, but goes directly to the commissioner and asks that charges be filed against another person. So the answer is that as soon as you get wind of that, it is worth your while to make a consult with a competent criminal defense attorney. The reason being that when people have that rare heads up that they may be actually charged, even if they never get charged, it's important for them to know how to handle that oftentimes very limited window. So for instance, if there is some type of offense where someone thinks that someone is making either a child abuse or a sexual abuse allegation against them, they may get a call from a detective and ask them to come in and speak. And oftentimes, many people think, well, if I just explain what happened, it'll just all go away. And every criminal defense lawyer of experience knows that many, many cases are complicated by someone saying what they feel are innocuous statements that they never meant to incriminate themselves with, that do just in fact that. They can be seen from a lot of different angles, and certainly a person going in to speak to someone without an attorney by their side is making a very, very foolish decision. So if they book a consult and come in for an hour and go over what might be going on in the case and how to respond if the person is questioned or confronted, that in and of itself could make the difference between whether a charge actually gets filed or not. And even after that, if they choose not to speak to the police, or a charge actually does get filed, or there's the beginnings of a charging decision. In fact, in particular in child abuse and sex offense cases, in most of the jurisdictions in the state of Maryland, there's a period after the investigation begins that the detective has to present their case to a group of prosecutors, and then they ultimately decide whether the charge will be filed or not. And that's an important time to engage a lawyer to be able to have that person make the best argument for why you should not be charged. Anybody, I have martial arts experience. I used to teach Taekwondo years ago, and anybody that is involved in martial arts will tell you it is much safer not to be in the ring than to have to be in the ring. So if you can prevent a charge from actually getting filed, you are doing that person such a service instead of having to be on the defense and having them be indicted or be criminally charged in a court. And what's really important during that phase is that most people don't understand is that to invoke their right to counsel, they have to do it personally. You're going up against somebody that has been trained in oftentimes multiple trainings to break that person down from invoking their right to counsel and to seek them to give a statement without them asking for a lawyer. So the likelihood that they're going to be able to, no matter how well prepared they are, to prevent that from happening is pretty much nil. So what we do in this firm is that if someone does engage our services while they're being investigated, we provide them with a letter that they sign themselves indicating that they want their lawyer to be contacted. And because I didn't sign up for a 9-to-5 job, that letter includes my cell phone and includes the fact that I'll take calls on nights, weekends, and so forth, which I certainly have, so that that right to counsel can be preserved.